Kia ora, ngā mai ki te whare. Welcome to The House, ko Louis Collins aho. Whether it's the Three Musketeers or the Bee Gees, some of the most memorable groups come in threes. New Zealand politics too has its own trio, the three branches of government. On this program we put a lot of focus on two of them, the executive, ministers making the calls, and the legislature, parliament passing the laws. But what about the third member of the three, the judiciary? To shed some light on the critical relationship between the courts and Parliament, I headed across the road to Victoria University Law School and spoke with the school's dean.
Hi, I'm Geoff McLay. I'm a Professor of Law at the Victoria University of Wellington. I'm currently the Dean. We're in my office in the old government buildings, room 203, with a very good view of the Constitution sitting outside ourselves, the Supreme Court to the left, Parliament and the Beehive to the front, and the High Court to the right.
Apart from being a mastermind subject for the Geoffrey Palmers and Dean Knights of the world, what do we mean when we say constitutional law?
Well, constitutional law is really just an umbrella term for how we all just govern ourselves. The first and most important thing to say is what everybody agrees on, which is that in New Zealand, Parliament is sovereign. Parliament can make, in theory, any law that it wants to. And everybody agrees with that, or agrees that that's the Constitution. But there are obviously shades within that. It's the court's job to interpret what Parliament has done, and often that can be in cases that Parliament hasn't imagined, or situations that don't quite fit into the statute that Parliament has passed. And this is a common feature of the last couple of hundred years of first English judging and now New Zealand judging, that judges are forever confronted by situations that are not necessarily governed foursquare by the thing that Parliament has passed. And that's a natural process in any system.
So what's to stop a minister from saying to a judge, hang on, I don't actually like the ruling you've made here, and I don't think you've interpreted the legislation I've made properly?
Well, I think it's really important to distinguish between what a minister can do and what the legislature can do. And that's one of the current, I think, controversies. So a minister only makes law to the extent that Parliament has authorised him or her to make law through regulations or other kinds of executive orders. It's Parliament that makes the law. So ministers essentially are bound by the ruling that courts give. And that's really been a really significant part of the New Zealand Constitution. It's a very important part of the Constitution that on the whole, ministers have tended to abide by the decisions of courts. They have tended not to over-egg the criticism of judges, but essentially they're bound by the interpretation. If a judge says you can't do what you thought the statute said you could do, you just can't do it. But of course, what a minister can do is a minister can go back to Parliament and say, I need the law to be changed because this is not in accordance with what I thought it was, what it needs to be, what New Zealand needs it to be. And that's also a natural process of our Constitution.
Conversely, can a judge or the judicial branch in general scrutinise the other branches of government, and how do they go about doing that?
So to scrutinise the executive, a very important part of our High Court business is what we call judicial review, which is private citizens can take a case to the High Court which says the minister just doesn't have the power to do a particular thing. Parliament didn't give him or her that power. Or the minister has behaved unreasonably or has made an error. There's a whole raft of judicial review grounds. And that's an important part of our function. That's reviewing what we would call executive actions. There is no supreme law constitution in New Zealand, and so we don't have what you might call hard-form judicial review, the ability of judges to strike down statutes.
In terms of scrutiny, the public are constantly seeing scrutiny of the executive by Parliament, particularly by the opposition. But are there the same avenues for scrutiny of the courts?
One of the important parts of the New Zealand Constitution is that we get to say what we think about judges within reason, within the constraints of being in a civil society. But judges are subject to a great degree of criticism in the media, through my colleagues, through activists. There's an important part of our Constitution where judges are subject to that. There is a convention, and there's been an important convention in New Zealand which says that while you might say that you disagree with the legal decision, you will abide by that legal decision if you're a minister. There are rules that are well understood, I think, that we shouldn't criticise the judges so much. We can criticise the decisions that they've made, or the state of the New Zealand law which they have revealed, but Obviously, the big thing that can then be done is if the judges are making decisions that you as a minister don't like, you can't change the law, but you have to go to Parliament and try to convince Parliament to change the law. And if you're a minister, obviously you're part of the government, so you probably have a reasonably good chance of convincing Parliament of doing that. Still, it's Parliament that does that.
Where does the Attorney General fit in all this? Because there's sort of like a bridge between the two branches of government, right?
You're exactly right. The Attorney General has a really important role whereby before legislation comes in, and before legislation is passed, the normal process is it goes through a whole vetting process. One of the important vets that is done is obviously for the compliance with the New Zealand Bill of Rights, to check whether things are infringing with the rights and freedoms, like freedom of expression or right to religion, etc., etc. That's a formalised process within government. The Attorney General sits at the top of that, and it's the Attorney General's job, as the current Attorney General has done and as previous Attorney Generals have done, to report to Parliament when particular legislation is inconsistent with the rights and freedoms in the Bill of Rights. New Zealand has, unfortunately, a bit of a record, though, of Parliament just continuing, nevertheless, to pass those, but it's supposed to be a warning sign.
Now, let's say Parliament is going back and amending a bill that they think perhaps hasn't been interpreted as they intended or isn't fit for purpose, and the judiciary thinks that the new version of the bill also probably won't be an improvement. Can they recommend changes?
That's a really complex question. New Zealand judges tend to be, in my experience, very wary of trying to influence Parliament directly or even indirectly. I think they take the view that it's their job to determine what the law is. But there have been some notable examples where there have been submissions made. But typically, I think judges give a degree of deference back to Parliament, that they have deference from Parliament in the particular decisions they make. Parliament ought to be given deference in the decisions it's making. But obviously judges are also involved in a number of, I know in the criminal law space, judges are part of the committees which consider the kinds of proposals that need to be made to modernise the New Zealand justice system. And they do influence law development in those ways.
Just circling back to the criticism of judges, there's been this trend in political discourse overseas, mostly from the States, around activist judges. And we've seen that term used a bit here recently. Can you just explain what an activist judge actually means?
Activism is kind of one of those things. There's a very famous court case in America where a judge said, you can't define pornography, but you know it when you see it. I get the sense that often when people talk about activist judges, they're doing the same kind of thing. That it's very difficult to actually say what people mean by activism. They often think that people are developing the law, the common law, the law that judges have always made in our country, in a way they don't like. And there's some criticism of that in relation, particularly at the moment, to using tikanga Māori in judicial decisions. That kind of is a bit of a strange criticism because judges have always developed the law. That is part of our constitution, that judges have a lawmaking role in relation to what we call the common law, the law that's made by judicial precedent. But it's always been part of our system here for the last 50 years. There's always been criticism. Some judges do too much, just as there are other people who wish judges would do a lot more in their decision making. And that's one of the balances of lawmaking, decision making, is there's always been this comment. That's one part of judicial activism. The second is the relationship to Parliament. And so there has been quite a lot of criticism from some quarters that the Supreme Court in particular is being activist in not doing what Parliament has told it ought to do. It gets back to our earlier part of our conversation. Judges have always and always will have to interpret the words in front of them. And sometimes they will do that in a way that politicians or even the parliamentarians that passed it or the drafters who wrote it wouldn't have agreed with. That can't be activism. That's just the judicial function. My understanding of some of the claims at the moment is there's a belief amongst some people that judges are going further than that.
Because judges are appointed, I guess the concern is that you've got individuals that weren't democratically elected making decisions on behalf of the public. How are judges appointed?
So judges in New Zealand are appointed by the government, or effectively. They, in theory, are appointed by the Governor-General, but they're appointed on the advice. High Court judges are appointed on the advice of the Attorney-General. In New Zealand, the tradition has been for a very long time that is an apolitical decision. But if you look at the kinds of appointments that are made, at least to the High Court, which it's very easy to track because there aren't that many High Court judges, they're exactly the kinds of people you would think ought to be appointed. They're people who have a great deal of legal experience. They're people who have been senior lawyers, mostly senior court lawyers. They're people who have a track record of service to the profession and are well known to the profession. There are, I could tell you the political views of some of those people. I could tell you political views of others of those people, perhaps, but that's not at all relevant to the decision or the way they see their jobs. And there's been a little bit of criticism recently of some of the judges' personal political opinions in sort of previous lives. I think on the whole that would not be seen as relevant to the current appointment system.
So what's to stop the Attorney-General from appointing an old mate or someone who's in with the party and stacking the courts in the government's favour?
First of all, you have to figure out why you would stack the court. So the first question is, what would you gain by putting people of your political views on a court? That would be one basic point. If you're the Attorney-General, what you want are competent judges in order to administer the justice system in New Zealand, and that's been our tradition. You could have a system of more formal safeguards. So when I was on the Law Commission, we were asked to consider whether there ought to be an independent commission.
What would that actually mean?
So you might have a group of community people who are appointed to a commission who would do the recommendations rather than the Attorney-General. In the end, I think the conclusion the commission reached at that time was that it wasn't clear that that would actually benefit the system much more.
Do you think the relationship between Parliament and the courts is a durable one?
I think the most important thing to say is that there always is going to be some argy-bargy between the way people want New Zealand to be governed and the way New Zealand actually is. There's always going to be people in Parliament, there's always going to be ministers who would like to do things that they can't do or that judges tell them they can't do, or they're going to be ministers or officials who are going to be frustrated with what a judge has told them a law means or didn't mean. And that's part of a healthy democracy. That is what democracy is. We don't have to agree with everything that is done by people. And it's right, I can see why a minister can be frustrated for wanting to do good, they perceive it being good things. But if you look at our history, New Zealand has an incredible history over the last, really since the 1890s of having a system which is perceived as being politically independent, of having very good lawyers appointed to be the judges, and on occasion having pockets of criticism being directed towards the decisions that judges are being made. I think the difficulty has always been over that 120, 130 years, is when it becomes a little bit more personal. So I'm very hopeful that everybody in New Zealand wants to be in a country with the rule of law. We all agree on that. We all know that in order to have the rule of law, we need independent judges. We need people that make the law in Parliament. We need people who administer the law, and we need people who can interpret the law. And by the by, my sense is that judges stick to their lanes in the same way that ministers in Parliament stick to their lanes. And the reality is in New Zealand, although we might focus on some particularly high-profile judicial decisions, the Parliament lane is much bigger than the judicial lane. Parliament is the one who makes policy, and it makes law, it makes most of the law of New Zealand. Parliament is the one with ultimately all of the cards in terms of what it wants the law to be. Ministers are the ones who are doing the policy making in New Zealand by the by. Obviously, there are cases where critics of particular decisions will say a judge has gone too far, that a judge has now used policy where they shouldn't have used policy, they've interpreted statute in the wrong way, they've used this principle, for example, I talked about the principle of legality to give too much emphasis to this right rather than the words that the particular phrasing the Parliament has used. But those dynamics are always going to be in any system.
That was Geoff McLay, Dean of Law at Victoria University. I te whakarongo koe ki te whare. You've been listening to The House, a program made with funding from Parliament's Office of the Clerk. Mā te wā.